Dara, Lakshmi, Narayan and others. Versus State of Telangana and another. The appellant number 1 Dara Lakshmi Narayan married the respondent number 2 on 8 March 2015 as per Hindu rites at Chin Keshavaswamy Temple, Markpuram, Andhra Pradesh. The couple resided in Jollarpeta, Tamil Nadu, where Dara Lakshmi worked in Southern Railways. Their 2 minor children who were born in 2016 and 2017. A matrimonial dispute arose between the husband and the wife mainly because of the wife's regular uninformed disappearance and her relationship with another man. The wife filed a complaint against her husband, her in-laws and her brother-in-law. The complaint was registered as FIR number 82 of 2022 on 1st February 2022. The alleged offences fall under Section 498A of the IPC and Sections 3 and 4 of the Dowry Prohibition Act. The case was filed at the Narayan Police Station, Rachakunda. The husband and the in-laws filed criminal petition number 1479 of 2022 under Section 482 CRPC and sought quashing of FIR number 82/2022 dated 1st February 2022. The High Court refused to quash criminal proceedings against the appellants and directed the investigating officer to follow the mandatory procedure under Section 41A of the Criminal Procedure Code, as well as follow the guidelines provided in the case of Arnesh Kumar vs. State of Bihar, 2014. The High Court directed the investigating officer not to arrest appellants until the charge sheet is filed. The High Court further noted that the case involves matrimonial disputes between the husband and wife and observed that custodial interrogation is not required in such matrimonial disputes. The appellants appealed to the Supreme Court.
In the Supreme Court, the appellants argued that they never demanded dowry from the wife. The husband claimed that his wife repeatedly left the matrimonial home without notice. On one occasion on 3rd October 2021, appellant number 1, the husband, filed a police complaint. And 2 days later on 5th October 2021, the wife was found living with another man. After counseling, she returned. The husband further argued that in a letter dated 11th November 2021, written to the police, the wife admitted leaving the matrimonial home due to a quarrel over her relationship with a man named Govindan, with whom she had been frequently interacting. She promised not to repeat such actions. However, she left again, prompting the husband to send a legal notice on 13th December 2021 seeking mutual divorce. The FIR of 1st February 2022 was allegedly filed as a retaliatory measure. The in-laws claimed that no specific allegations were made against them in the FIR and that they did not live in the matrimonial home. Their inclusion in the case was argued to be unjust.
The respondent wife argued that the FIR discloses sufficient evidence against the appellants alleging harassment for additional dowry and physical and mental abuse of the wife. The wife also claimed that the husband regularly came home drunk, had an illicit affair with a woman named Monica, and abused the wife after marriage. The wife further claimed that her in-laws provoked and instigated the harassment.
The Supreme Court held that the FIR filed by the wife lacks specific details regarding harassment under Section 498A of the IPC and the provisions of the Dowry Act. There is no mention of the time, date, place, or the manner of the alleged harassment. There are only general allegations against the husband and his family without any concrete evidence. The wife left the matrimonial home on 3rd October 2021 after a quarrel with her husband over her phone conversations with a third person named Govindan. She later wrote a letter on 11th November 2021 admitting that she had voluntarily left and that her husband took good care of her. Despite assurances, she left again, abandoning her husband and her 2 minor children. The Supreme Court further observed that when the husband filed for mutual divorce on 13th December 2021, the wife, instead of responding, lodged an FIR on 1st February 2022 under Section 498A IPC and the Dowry Act, which the court deemed as a counterblast to the divorce proceedings. The Supreme Court further held that the husband's family members lived in different cities and had no direct involvement in the matter. There are no specific allegations or evidence against them, and that they were falsely implicated in a generalized manner. Finally, the Supreme Court quashed the FIR number 82 of 2022, along with the related charge sheet, as well as the trial proceedings. The appeal was allowed and the High Court's order was set aside. The Supreme Court ruled that the FIR was motivated by retaliation, lacked credible evidence, and was an attempt to misuse legal provisions.
Thanks for watching.